All right, let's jump right in. We all make promises, we all make deals. But what's the real difference between a casual comment and a promise that's legally locked into a contract? We're going to figure that out by looking at 8 absolute legends of contract law. And trust me, these aren't just dusty old cases. They form the rule book that courts still use today to figure out who promised what.
So, picture this. You're buying a used car. The seller, a nice guy, tells you, oh yeah, it's only done 20,000 miles. You shake on it, buy the car, and then disaster. You find out it's actually done over 100,000. So what's the deal? Was that just friendly sales patter, or was a rock-solid, legally binding promise just broken? That exact question is what we're digging into.
And here they are. This is our lineup for today. These 8 cases are going to be our guide. We've got everything from dodgy car deals to rusty ships, and each one teaches us something crucial about how to separate empty talk from a real contractual term. Let's get to it.
Okay, so here's how we're going to break it down. First, we'll look at what actually makes a promise stick. Then, we'll dive into all the unwritten rules hiding in contracts. After that, we'll see what happens when things go wrong and a promise gets broken. And finally, we'll wrap it all up with why this old-school law still matters so much today.
All right, first things first, the big question. When you're making a deal, people say all sorts of things. So how do the courts tell the difference between some casual remark and a statement that's actually part of the deal? Well, a lot of the time, it all boils down to one key thing: expertise.
Check this out. This is the perfect showdown. 2 cases, both about used cars, but with totally different outcomes. On the left, in Oscar Chess, you have a private seller, just a regular guy, who gets the car's age wrong when selling to a dealer. The court basically said, hey, he's no expert, he just read the paperwork wrong. It was an honest mistake, so not a binding promise. But on the right, in Dick Bentley, you have a professional car dealer who gets the mileage wrong when selling to a customer. And here, the court came down hard. Because the dealer was the expert in the room, their statement was treated as a fact a buyer could rely on. It was a binding term of the contract.
And that right there is the key takeaway. It's what lawyers call the special knowledge test. Basically, if you hold yourself out as someone who knows what they're talking about, whether you're a mechanic, a software developer, or a financial advisor, the law expects more from you. Your statements carry more weight. So you see, it's not just what was said, but who said it. That changes everything.
Now, the courts took this idea even further in the case of Esso Petroleum. Here, the oil giant Esso gave a wildly optimistic sales forecast for a gas station to a guy who was thinking of leasing it. And, surprise, surprise, the forecast was completely wrong. The court got creative. They said, look, that forecast wasn't technically in the main lease agreement, but it created a collateral contract, like a little side deal. The promise was, our expert forecast is solid, and that promise convinced him to sign the main deal. It's a really clever tool that still applies today, like when a startup's big promises in a pitch deck lead an investor to sign on the dotted line.
Okay, so we've talked about what's said out loud, but what about all the stuff that's left unsaid? You know, contracts can't possibly cover every single tiny detail. So sometimes courts have to read between the lines and fill in the gaps with terms that everyone just sort of assumed were there. You can actually see the court's thinking on this evolve over the years. It started way back with a case called the Moorcock about a ship getting damaged at a wharf. The court said, well, of course there was an unwritten promise that the riverbed was safe. Without that, the whole contract would be pointless. That gave us the business efficacy test. Then came the famous officious bystander test. The idea is, if a nosy person was watching you make the deal and asked, oh, are you including this term? Would both of you have said, well, duh, of course. If so, it's in. More recently, the thinking has been simplified to just ask one big question. Looking at the whole picture, what would a reasonable person think this contract actually means?
But wait, there's a whole other category of unwritten rules. In Liverpool City Council v. Irwin, you had tenants in a tower block whose lease said nothing about who was supposed to maintain the elevators and stairwells. The court stepped in and said, basically, look, in some types of relationships, like a landlord and a tenant, the law itself is going to write in some basic obligations. This isn't about what the parties intended, it's about public policy. It's the law saying that for a rental agreement to be fair, the landlord has to keep the common areas in decent shape, period.
So we know what a term is, whether it's spoken or unspoken. But what happens when somebody breaks one? Can you just tear up the contract and walk away? Well, not so fast. The law says it really depends on just how important that broken promise was. And that brings us right to this question. Because no, not every broken promise is a complete deal breaker. A classic case called Hong Kong Fur Shipping really put this to the test.
A company chartered a ship for 2 years, but it had to go into dry dock for repairs for several weeks. The charterers wanted to cancel the entire 2-year deal over it. So the court had to decide, was the promise of the ship being seaworthy so fundamental that any little problem was enough to sink the whole contract?
And the court's answer gave us this incredibly useful 3-part system. First, you have a condition. This is a major term, a real deal breaker. If a condition is breached, you can terminate the whole contract and sue for damages. Then you have a warranty. This is a minor term. If it's breached, you can sue for damages, but you can't just walk away from the deal. And then there's the flexible middle ground, the imminent term. Here, the court takes a wait-and-see approach. It looks at the actual consequences of the breach. Did it destroy the whole benefit of the contract for you? If so, you can terminate. If it was just a minor inconvenience, you can only get damages. It's a very practical solution.
So, let's pull all this together. Why do we still obsess over these old cases about cars and ships? What's the big deal? It's because the common sense ideas they developed created a framework for judging agreements that is so flexible and so powerful, we still use it every single day, in everything from buying something online to billion-dollar corporate mergers.
All right, let's boil this all down. What are the big ideas you should take away from this? First, if you're an expert, your words matter a lot. Second, contracts have hidden rules that courts can add in to make them work or just to be fair. Third, not every broken promise is a nuclear option. The remedy has to fit the seriousness of the breach. And ultimately, what's the point of all this? It's to bring a dose of fairness and predictability to our agreements.
And I want to leave you with one final thought to chew on. All these tests, the officious bystander, the reasonable person, they're all incredibly human, right? They're about common sense. But we're moving into a world of smart contracts, of AI-driven deals written in code. So the massive question is, are these old-school, human-centric ideas still going to work? Or are we going to need a whole new legal playbook for the future of contracts? Something to think about.